Good morning, everyone. My name is Kevin Bill. I'm the Deputy Director for the Office of Equal Opportunity Monitoring and Compliance at the Illinois Department of Commerce and Economic Opportunity, as well as the State WIL Equal Opportunity Officer. I would like to thank everyone who has signed up for this training this morning. The presentation I will be conducting today is titled The remaining presentations would be what I consider most conducive for you as you're working in the capacity as an EO officer. For many of you all, I have been in this capacity about a year and 4 months now, and I have yet to meet many of you all, so I decided to share a brief bio on myself to provide a little background of on where I come from and what I have done relating to both the public and private sector. Before we get started, just a couple of housekeeping items. Notice the conference number are available in the file share pod, which is located in the lower left-hand corner of the screen. You can click on the full screen button above the presentation to view it as full screen to get back to the screen, or just click the full screen button again. You can use the chat pod to discuss among yourselves and ask questions. We will answer any questions at the end of the webinar, and we will be using polls throughout the webinar. In the event that my voice do drop, it's kind of still early in the morning for me. I do have a deep voice. And I'll tend to speak a little more clearly and loudly for you. I provided with you all with some polling questions just to try to get a more clear and concise understanding of what knowledge or prior knowledge you have regarding to retaliation law. And I see here that 100% have answered that you do not have any current or prior knowledge of retaliation law. I see that also and then for polling question 3, since I can't see it, can you read? Okay, gotcha. Thank you. Okay. The question I posed was, what can an employer do to minimize the risk of being the target of a compelling claim of retaliation? Mike answer, have a company policy that addresses the issue. Joanne answer, have a policy and training or train employees about retaliation. Jan stated, that's awesome. Thank you guys for sharing that information. Let's get on to the presentation. As indicated, the title of this presentation is RevengeisSweet for Plaintiffs, Recent Trends in Retaliation Law. I also have my 2 EO ADA investigator compliance officers with me. I'm sure you all have met them many times before, Randy Shelton and Tim Galino, who's here in support. They will also be conducting other trainings on my behalf in the near future. So starting off with retaliation law. Retaliation type of retaliation claim involves an employee who alleges that he or she was first harassed or discriminated against and later punished for making a complaint to her employer or relevant federal agency. The EEOC, the U.S. Equal Employment Commission, the Force Laws and Retaliation, all have an anti-retaliation provision, which many of y'all should be familiar with. As you can see on your screen, Equal Pay Act, the Title VII of the Civil Rights Act, Age Discrimination and Employment Act, employment practice made illegal by any of the federal employment discrimination laws is protected from retaliation. The protection is not codified in any one statute. Rather, it is found in varying forms of each of the federal employment discrimination statutes, Title VII of the Civil Rights Act, Age Discrimination and Employment Act, the Americans with Disabilities Act, and so forth. All 6 of these provisions contain language prohibiting retaliation because of an individual that has engaged in a protected activity. Federal employees who are protected from these types of discrimination include federal employees are not protected from retaliation by regulation. During its current term, the U.S. Supreme Court has continued a trend of issuing rulings that in the March 2011 employment law update, it was reported on the Supreme Court's ruling in Caston v. St. Gobain Performance Plastics Corporation, in which the court ruled that an employee was protected from retaliation even though they had raised his wage complaint only internally and not filed with the claims to agency or the court. In the January for his fiance's filing of a discrimination complaint against the same employer. As you can see, many of the retaliation claims, many of the justices do find in favor of the plaintiff who had filed a retaliation claim or charge. And actually, I think I'm going to take my jacket off. You can go in. The White Jacksonburg Birmingham Board of Education. Recent trends reveal that employment retaliation claims are on the rise. Further, courts are taking a hard line on offending employers accused of retaliation in employment. A review of the United States Supreme Court decisions, as I've provided for you, in retaliation cases reveals a remarkable degree of agreement among the justices. Even conservative justices who are considered supportive of businesses as a matter of judicial philosophy do not take kindly to retaliation against employees who have voted 6-2 in favor of the plaintiffs as well. And Thompson v. North American Stainless, they voted 8-0 for the plaintiffs. So as you can see, it's a very ongoing trend that the justices at our federal The bad news for employers is that the statistics show, as I presented here, that the EEOC charges are on the rise in all categories. The EEOC recorded nearly 100,000 charges in 2010, a record high in 2009. For the first time ever, retaliation charges were the most frequently filed charge in 2010. Charges increased 68% between 2000 and 2010. In 2010, the majority of EEOC charge receipts that were filed were filed for race, followed by retaliation, and thirdly, sex, age, and so forth. In fact, employees are making significantly more claims under the retaliation theory as a Over the last decade, a number of employment cases have reached the United States Supreme violation of wage and hour, as well as Title VII, age discrimination, and various civil rights laws which apply to the workplace. The same court that has made it more difficult for employment planners to maintain claims of workplace discrimination has been very expansive of the rights of employees who complain about retaliation. Later information, I just wanted to compare and contrast. Slight decrease in charge receipts with race beginning, followed by retaliation of sex being the primary complaints filed in the federal sector from 2000 to 2010. However, in respect to national origin, color, and religion, these particular categories tend to be relatively lower. However, keep in mind that these categories are relative and you can potentially address a complaint involving all that's shown here: race, color, sex, religion, national origin, age, disability, equal pay, and retaliation. Related activity or oppose unlawful activity. Generally assume that any current or former employee who does any of the following can be protected from retaliation. Asserts the claim that he or she or other victims of are victims of some discrimination, wrongful harassment, retaliation, or wage violation, regardless of whether they assert that claim in court litigation, a filing with the EEOC, Department of Labor, or other state or federal agency, or merely with the employer. Proceedings involving a claim of discrimination, harassment, retaliation, or wage violation. Any other employee who has a close relationship with an employee who falls in any of the categories above. Third party within the zone of interest of someone who engaged in protected activity that statute seeks to protect is something that they pointed out in Thompson v. North American Stainless, meaning that a third party can file a retaliatory claim on behalf of the individual who was discriminated against. Please note that the person raising the claim needs to be correct in that the belief that they were discriminated against in some shape, form, or manner. What is participation in the EEO process? It is taking part in any manner in a proceeding, investigation, hearing, or litigation as I indicated. Examples of protected participation include filing a charge or lawsuit in the federal sector, contacting an EEO counselor, serving as a witness in an EEOC investigation, or like I indicated, any person from engaging in similar protected activity for fear of suffering the negative treatment, such as including the complaining employer from meetings or work-related information, or generally shunning the employee who made the claim that they were retaliated against for whatever reason. An example that I provided for you all to kind of give you an idea in regards to some retaliation scenarios. Example one, Tim filed a charge alleging discharged. Tim is suspended, and his supervisor said that he should avoid making stupid complaints about bogus issues if you want to keep working in this shop. And I'm just curious to know, is this a form of retaliation by the employer? And I would like to know what everyone feels about that. That is correct. Retaliation law protects employees who assert rights protected by law, even when the employees turn out to be wrong Example 2, Marilyn filed a lawsuit alleging sexual harassment and unlawful termination from her position at Big Home Improvement Center. She applied for work with Large House Remodel Center in a position similar to her old job at Big Home, but was not selected. Based on comments from a friend who worked at Large House, Marilyn believes that she was not hired because her lawsuit was well known in the industry. She filed a charge against Large House as a poor job reference for a former employee retaliatory. Please answer. Of them I see could be. Need more info. Okay. Well, to answer the question, it's possible, Protection against retaliation generally follows employees after they leave employment. As a result, courts have allowed employees to recover damages resulting from retaliatory employee references. Courts may also treat unwarranted criminal counterclaim designed to intimidate the employee pursuing the lawsuit can be amount of retaliation. Again, if the employer's action will deter an employee from asserting protected rights, it can be performed on the basis of a retaliation claim. What is protected opposition? Is there any reasonable opposition to any practice made unlawful under the relevant anti-discrimination to be in order that one reasonably believes will make discrimination a term or condition of employment? Another example I provided for you all is Sally works as a payroll clerk in the accounting department aside from the department director who is on vacation and unreachable. Sally's the only person with the necessary authorization to make payroll payments. After being passed over for a series of promotions, Sally until her complaint is investigated. 15 minutes after seeing this message, Sally is fired. Is this actionable? Please answer. Yes or no? The answer is yes. A bogus employer explanation is known as a pretext. Since an employee is in the best position to know why it discharged an employee, proof that the employee made up a bogus reason allows an inference that the employee is hiding an unlawful reason. That can be enough for a jury to find that the real unlawful reason is retaliation. So that will not be in a good case for the employer. When can someone pursue a claim of retaliation? Which is considered, this is a lower standard that is applied to discrimination claims that do not involve retaliation. The U.S. Supreme Court recently defined how the employee must suffer to have a tangible employment action, for example, as we see in Burlington Northern and Santa Fe v. White from 2006. There, the Supreme Court defined a tangible adverse action as one that would have been materially adverse to a reasonable employee or applicant. A retaliation plaintiff must show that the challenge action might have dissuaded after she made a complaint, but then reversed course and paid the employee for her lost wages. The question before the court was whether the adverse action, the suspension, was tangible. Because the employees ended up not losing money, the court said it was since, based on the test quoted above, a reasonable person would not make the complaint in the first place, knowing that she will go 37 days without pay or an insurance of being paid. Other possible examples may include transfer to an undesirable location, a serious loss in responsibility, or prestige or placement on a lousy shift if they Example 4. Mescula filed an age discrimination charge concerning his employer's decision to reassign his highest commission clients to younger workers. Shortly after the EEOC notified his employer, Fat Cat Investments, of the charge, his manager instructed IT to provide regular reports on his computer usage and ordered 2 co-workers to keep him under surveillance and regularly report back on his activities. Is this actionable? And for the majority, you all answered correct. That is correct. The answer is yes. Good job. Example 5. After Jennifer testified at her coworker's disability discrimination hearing, her schedule was changed from 7 a.m. to 3:30 p.m. to 9 a.m. to 5:30 p.m. This required Jennifer to completely reorder her private job because it will allow her to spend time with her children in the afternoons. Is this example actionable? Please answer. And the correct answer is yes. Evidence of discriminatory treatment is identical to that used to prove gender, age, race, and similarly situated employees who did not complain. They can also include a new employer policy that has a singular adverse effect on the complaining employee, in this case revising Jennifer's work schedule. Those who file retaliatory claims and charges must prove that they were discriminated against in some shape, form, or fashion. The person engaged in a protected activity or within the zone of interest, they must prove that they suffer materially adverse action that might well have dissuaded his or her from pursuing his or her claim or Be certain that the evidence justifying termination in the event that it gets to that level is totally independent of any legal claim previously made before taking adverse action against employees who complain, participate in, or are associated with employees who raise legal complaints in the workplace. Be careful to avoid taking action against employees only after they have complained. Defensible terminations are supported by well-developed documentation which follow what evidence is necessary to prove a retaliation claim. Employees must prove that they engage in protected conduct, that they suffer a tangible adverse employment action, and that there is a causal connection between their protected conduct and the adverse action. Now, improving causation is usually the most difficult part of a retaliation claim. Employees can prove a causation with evidence of the timing between pattern of adverse actions or hostility towards other complaining employees. And lastly, bogus explanation for the employer's adverse action or termination of the employee. Due to these alarming statistics that I shared with you earlier in the presentation, here are some of the simple steps that employers can take to reduce retaliation claims by employees. And as EO officers, I just would like for you to take time to read this thoroughly. So in the event that policy in place that is distributed to all employees. I believe some of you all mentioned that earlier in regards to training staff and having a policy intact for this type of situation. Provide trainings to managers, supervisors, and human resources personnel on the anti-retaliation policy. Don't ignore complaints of retaliation by employees, very importantly. Meet with the employee and the supervisor to discuss the policies that are in place to prevent retaliation. Investigate the claim, document discussions in writing, and follow up with the employee. Lawful conduct by the employer. Confirm that any actions taken against an employee result from a decision wholly unrelated to the worker's prior complaint of unlawful conduct by the employer. And make sure that you can document a legitimate business reason why the decision necessarily applied to the employee who raised the complaint as opposed to other workers, and be able to show that at the time the action was implemented that there was a genuine business need for it. Understand and recognize your employees' rights. Just take some time before you deciding to do or take any action. Make sure to including your human resources director and your legal counsel to talk about the matter at hand and the particular charge that has been filed. And always consult before taking any action. Feel free to contact my office if you feel that you don't know what direction to take. You can always feel free to contact myself. Claim are fairly consistent regardless of the underlying statute. To establish a prima facie case of retaliation, a party must show, once again, that he or she engaged in protected opposition to discrimination, or he or she participated in a covered proceeding, that he or she suffered an adverse employment action contemporaneously or subsequent to such participation or opposition, and thirdly, a causal connection exists between the protected activity and the adverse action. One of the reasons I chose retaliation law in the near future, moving forward, working in the capacity as EO officers, my job is to provide necessary training for you all to allow you to be more conducive and beneficial in working in your capacity as EO officers, and there would be all type of situations that would transpire, in which it's my job to ensure that you're well prepared for these type of situations. So once again, it was nice to meet you all who all participated today in Retaliation. I know. Okay. Jan Terry has a question. What kind of resolution might be made for retaliation suit? Jan wanted to know, such as an example too, with the poor performance in the event that the person filing the charge, they can come to you and to seek guidance and direction on how they want to move forward. Now, there can be some resolution in regards to sitting back down with the HR director to determine why we did receive a very, poor reference. However, many times, as you can see from the court cases that are provided to you, the justices will, they will grant in favor of the plaintiff making the charge only if it's a valid claim. You will see in the near future, we're doing our very best to try to come back and determine how to address all of these issues, as I'm sure that they will transpire and develop in the near future. Are there any questions for me at this time? To provide a list of refresher courses for you all. I believe Tim conducted a presentation on investigative procedures on Tuesday, which should try to, refresh your memory on what it is that you're supposed to do clearly and concisely as it is in conducting EO investigations. Randy will be conducting a presentation on Tuesday in regards to the methods of administration. So please review your MOA. If you have any questions regarding what it is that you need to do. As an EO officer, please contact my office. That's why I'm there for. I originally had a presentation that was scheduled for